King, I see you, and you're in the co-host box. Can you hear me?
I can hear you fine, loud and
Great.
clear.
Wonderful. Hopefully that will continue for the duration. And just so everybody knows, I've got my hubs, Steve, here with me. He's not going to log in separately. He's sitting next to me. And I've sent Ship a text message to see if he can join. He is super busy. He has a filing tomorrow. He has some travel. He may or may not be able to join us tonight, but hopefully he's going to. So I sent him a text reminder. So hopefully he'll chime in if he can. Let's see. Yeah, he hasn't answered me back yet. So, all right. So hopefully we'll see Ship. Excuse me. So tonight, what we wanted to do, at least the three of us, is do a very short, for us anyway. We had a 3 hour marathon last time we did this a few weeks ago, which we're not doing 3 hours tonight, you guys. Um, but short for us, so maybe half an hour, 45 minutes of what's going on with several cases that I know are of interest to the right of center is how I always think about it, because as a libertarian myself, I always think the right of center really is consisted of moderates who are on the right. They may not be very far over to the right, but they are on the right, and conservatives who are obviously solidly on the right, and then libertarians like myself who are way over on the right. And right of center is how I think of all of us collectively. So, right of center, I know, is going to be interested in these cases. We're going to talk about Hunter Biden's case, which the appeal court ruled on this week, Steve Bannon's case, which our circuit ruled on here. Steve's going to tell us about that. And then we're going to talk about a little bit about Mark Meadows' case, where he tried to remove his case in Georgia with Fannie to the federal courts. We're going to talk about that. And King, you had a couple of things you wanted to talk about with respect to that case too. So we're going to cover all of those. And then um, we're not going to cover tonight, you guys, the former president's case in New York. None of us are New York lawyers, and I know we're all watching that, but nobody's keeping a super close tabs on it. But obviously, as that case gets closer to the finish line, I think we're gonna turn to that one as well. And but we'll do that as a separate thing. The other thing we're also going to do separately in the not too distant future, and then I think later on this summer, is talk about President Trump's case in Florida in the federal court having to do with classified documents and the raid on Mar-a-Lago and that kind of thing. So we're going to touch on that just briefly tonight because I think we want to talk about the most recent order from the court there, how that's going to affect scheduling. But we're not going to talk substantively about those two cases, New York or Florida, tonight, but we are going to in the future as things roll along. And then for anybody who listens to us regularly, obviously we are going to talk about the decisions by the Supreme Court, which should be coming out this month or next month, July 4th, probably at the latest, on several cases that are obviously of interest to the right. So the immunity issue for the former president, the Section 1512 prosecutions of the J6 defendants. So those things are coming, but we're not going to talk about them tonight. Okay, so let's get started. Um, King, let's start with you. Let's talk about Mark Meadows. I think we have the shortest section on him tonight. So, have you looked at procedurally? I did look at it just before we logged on, but if you've done that, I'll let you explain it.
Yes, we're nothing has changed in his Georgia appeal. What he appealed was the federal district court's denial of his removal petition to remove the case that Fonnie Willis brought in state court. Uh, uh, that he removed it to federal court, district court denied it. He appealed to the 11th Circuit. They issued a ruling not only denying his right to remove on the same grounds that the district court did, but they also said that since he was merely a former federal official, uh, he had no statutory right to remove at all, regardless of the facts or the merits of his immunity claim. That for the first time in, I don't know how long that removal statute's been on the books, but since it was written, this
Long. I think it's sort of like immediate post Civil War
okay. Well,
originally. Yeah,
in all that time, this is the only court to have held that it's limited to current federal officials, does not apply at all to former federal officials. Uh, he asked for an en banc, which means the entire court review of that opinion, and they shot him down without an.
right,
They did not write a separate opinion. They just denied his en banc review. Uh,
right.
he has until sometime later this month to apply for uh, writs, writ of certiorari with the Supreme Court, which he
I
is
have that. He hasn't done that yet, right? That's what I
right.
have. Right.
It's not due. I think the deadline is like the third week of May.
I have it as the 28th. So the Court of Appeals denied the petition for rehearing on February 28th, and it's 90 days, right?
Right.
Unless you ask them for more time, which they can give you. But I don't see anything on the Supreme Court docket from for him yet. So he has not asked for an extension. So the normal 90 days, I think his last day to file is May 28th, so he's got a few weeks left to go.
He, he has announced, or his lawyers have announced, they intend to file
Right.
with the Supreme Court. Uh, while that, while all that's been going on,
Well, before we get to Arizona, let me ask you this, and
I,
Steve, I think, has a chime in here too. So the case went back. It's back in the Georgia State Court, right? Because the 11th
yeah,
Circuit said
it
we,
was, yeah.
right,
He asked for a stay of the case pending his all of his appeals. That was denied, and so he did file a the same immunity argument that he'd made in his removal papers. Uh, so that's pending in the state court.
right.
Uh,
So the state court judge said, I'm not giving you a stay while you decide whether you're going to file in the Supreme Court. And Meadows' lawyers have not asked for a stay of from the Supreme Court itself yet either. But Steve had an observation about this, but why would he not have done that yet, Steve?
Because meanwhile, you've got the whole issue of whether Fannie Willis can prosecute the case on appeal before the Georgia Court of Appeals pursuant to the interlocutory appeal that's been in all of the papers.
So
I would add that when we're talking about Mark Meadows, it's good to bear in mind that Mark Meadows is represented by George Terwilliger, a former Deputy Attorney General of the United States, and someone who I know personally from many years ago, being in the U.S. Attorney's Office in D.C. together, and a guy who is a straight shooter and a first-class attorney. So uh, King has said he's announced that he's going to seek cert in the Supreme Court. That's not for show. When Terwilliger says he's going to do something, he's going to do it. So they are going to seek cert in the Supreme Court.
yeah, they're just not wasting time and money trying to get a stay from the Supreme Court yet. Probably mostly because the case in Georgia is all tangled up with this question about whether Fannie Willis can be kicked off the case herself. So we do expect Mr. Terwilliger to file on Meadows' behalf on the 28th, but he may even then not ask for a stay. King, do you have any idea when the Georgia Court of Appeals is going to take up that case as to whether Fannie should be kicked off?
they've taken it up this week.
Right, but I
They
mean, what's the schedule? Do you any ideas?
no schedule yet. I think yeah, they gave the defendants who are trying to get finally kicked off. They gave them 10 days to file a notice of appeal.
Okay.
So that tells me that they're going to follow the standard timetable for handling appeals in that court. Uh, I would be surprised if all of the defendants don't ask for a stay of the case pending that appeal.
Right.
Right. So let me jump in here to say, when King talks about filing a notice of appeal, a notice of appeal is not a brief. It is a one-page pleading that says we appeal this particular decision. So the brief is months away, and by the time you get done talking about the briefing schedule and argument before the Georgia Court of Appeals, you're probably talking after the election, don't you think, King?
Yes, I would. Generally, state court appeals in most places run 6 to 12 months.
Right. So assuming nobody asks for it to be expedited, or the court doesn't decide to expedite it itself, then it's looking like end of the year at the earliest. Now, as Steve has reminded us in several of the spaces recently, and so it's always good to bear this in mind. Civil appeals and criminal appeals are very different. So the courts do not like criminal appeals before the case is finished. And on the criminal side of the courthouse, the courts consider the case finished when the person is convicted and sentenced, both. The judgment in a criminal case does not come until the judge issues the sentencing order. So it is possible to do appeals before that, what lawyers call interlocutory appeals, meaning you've appealed before the case is final, but it's a lot more common in civil cases. And because it is uncommon in criminal cases, and because the courts don't want to encourage criminal defendants to come up with reasons to file interlocutory appeals, because they think criminals are doing that for purposes of delaying their day of judgment, then it it often is the case that the normal time periods for appeals for civil cases or for criminal cases after the person has been convicted look different from the schedule that the courts want to impose on criminal cases where the person has appealed before they've gotten convicted. So the normal thing of 6 to 12 months could be oh so correct, but the Court of Appeals in this case might decide to expedite it simply because, setting aside even any of the political issues, but simply because it's an interlocutory criminal appeal. Plus, there's also usually state statutes, federal rules and statutes say this too, don't they, Steve? That let criminal cases take precedence on the court's docket. And this is because you have a constitutional right to speedy trial, etc. And the courts are serious about that. They normally will try to move those kind of cases faster than the others. So, but all of which is to say that, George Terwilliger could easily get a decision from the U.S. Supreme Court, at least as to whether or not they will take Meadows' removal case before the Georgia Court of Appeals rules whether or not Fannie is staying on the case or not. Okay, so, but King, when we talked about this earlier today, you then pointed out that there's sort of another wrinkle for Mark Meadows. So tell us about that.
He's been named a defendant with I think a number of others. I forget the number. Uh, in the Arizona version of the Fonnie Willis case, it's another state prosecution arising out of the so-called fake elector scheme, uh, whereby the Republican side, after they couldn't get their electors certified, uh, met together, appointed themselves the Arizona electors, and put their names in to Congress as uh, the real electors, because they thought, because there was an election contest still pending, either with the court or the legislature. Uh, so to preserve their ability to uh, elect a president, should they be successful in getting the certification undone at the state level, they appointed these alternate electors. Uh, the prosecution, which is being brought by the Arizona Attorney General, alleges that was a fraud, violated state law, and Meadows is a named defendant. He will have.
The former president is not named in that case, right?
That's true, but Meadows is, and for basically alleging that he did the same thing in Arizona that he did in Georgia to try to help pull that off on behalf of Trump. He has the same defense in Arizona as to his uh, uh, federal immunity, and based upon the supremacy clause uh, that he asserted in Georgia. So I would be surprised if he does not remove that case to federal court and try to get out west a better form of justice than he got in Georgia.
Well, it'll be fascinating to see if the federal courts out there rule differently than the federal courts in Georgia did. Then that could bubble up on that side. So even if the Supremes were to deny Terwilliger's petition for cert in Georgia, if the Arizona courts go the other way, um, well, if they went the other way, then I guess George wouldn't have to appeal for Mark, would he? But if you had two different rulings from two different federal courts of appeals on this exact same issue, basically, for the same defendant, I would be interested to see if the Supremes take that into account.
I think they would. That's one of the factors that they look at as to whether, technically, they look at whether there's a split in the circuits. That is, the circuit court in Georgia ruling one way, and the appellate court in uh, Arizona. Is it in the Ninth Circuit? I'm not sure, but if
Chip
it
would know.
ruled
He's not
if
here.
if it ruled a different way than the 11th Circuit did, that's pretty strong grounds to get the Supreme Court to grant certiorari.
Well, it might be the government then trying to get the court to take it, right? So you'd have
Yes,
George and on Meadows' behalf here on the East Coast, and the prosecutors in the Arizona courts out there. And then we run into the interesting question that we posited when we first started talking about this removal issue last year of because every circuit seems to handle these removal issues differently. So is the federal prosecutor's office out there going to get involved, or are these state court prosecutors going to be the ones bringing the cases in the federal court? How's that going to work? But it would be somebody for the government um, trying to bring it up there. So that it usually does increase the odds the Supremes will take something if you've got competing circuits. Now, honestly, they usually wait for more than two circuits. They usually wait for the law to develop. But on something like this, there's not going to be a ton of cases on this issue ever. So they sometimes will take it when there's only a few circuits weighing in. So it's a fascinating for lawyers anyway, thing to keep an eye on. So we are going to be watching that. Okay, so let's turn then next, unless, King, did you have anything else you want to talk about with respect to Mark Meadows?
no,
Okay, so let's turn to Bannon's case. Did you see the opinion from the DC Circuit on him? Did you have a chance to look at that or not, King?
I looked at it briefly. Kind of got the
Got the gist of it, huh?
gist of it. Yes.
Yeah. All right, so Steve's going to tell us a little bit about that. All right, so Steve, tell us about Steve Bannon's appeal and what happened this week in the circuit.
Well, Bannon was subpoenaed to appear before the J6 committee in Congress, and he basically refused to comply with the subpoena, and was prosecuted for contempt for refusing to comply with the subpoena. The defense he attempted to mount was a reliance on the advice of counsel, because his counsel had advised him that he need not comply. But the trial court ruled that reliance on the advice of counsel is not a defense, and the Court of Appeals upheld that ruling. The Court of Appeals decision relied on a circa 1960 decision called Lucavoli from the circuit, which had said that reliance on the advice of counsel is not a defense. And the court held in essence that there had been nothing that had happened since in terms of intervening Supreme Court law to cause them to change their view of that, and also that it would be unworkable for Congress to mount investigations if they couldn't compel compliance with their subpoenas. Now, in my own personal view, uh, about which I've written before, the I don't necessarily agree with this. The reliance on the advice of counsel is a well-established defense. The Supreme Court has ruled subsequent to Licavoli that willfulness, which is the term used in the statute here in terms of responding to a subpoena, that willfulness requires knowledge that you're acting contrary to the law, which would open up an advice of counsel defense. And the court, in terms of the unworkability, I think there's a distinction, and I think the statute recognizes this, between two things. One is whether you have to appear in front of Congress in the first place, which is what was at issue with Bannon. The second is once you're there and you're responding to questions, whether when you have an objection to a particular question that you're asked, you can rely on the advice of counsel not to answer it. And the Supreme Court has said in the later context, in the question by question context, that reliance on the advice of counsel is not a defense. They said this in a decision circa 1927. And for the eminent practical reason that when you're actually asking the questions, you've got to get answers on the spot. And if you rely on the advice of counsel, then your attorney, whoever he or she was, would effectively be able to countermand whatever Congress wanted to ask you. But that's the different issue from whether or not you ought to be able to rely on the terms of you have to respond to the subpoena in the first place, and in particular because of a privilege. And in his claim for long, that he was asserting executive privilege. Now, the circuit went out of its way to point out that on the facts, Bannon's claim was pretty weak on that because Trump and Trump's attorney had not told him unequivocally to go ahead and assert advice of counsel. They had been very careful in what they told him. But that's different. That's a factual issue. That's different from the legal issue of whether you can even raise advice of counsel. And the DC Circuit ruled that you simply can't raise it. So whether Bannon will seek to take that up to the Supreme Court remains to be seen. And I think that it's an open issue.
Right. King, have you got some comment on that?
Yeah, by way of background, the advice that Bannon got from his lawyer related to a separation of powers issue. To what extent does Congress have the power to subpoena subordinate officers, members of the executive branch? Usually those things are worked out by the two branches of the government. When Congress wants to subpoena a person who would show up and assert executive privilege to everything being asked, that they try to work it out without going to court or without citing somebody for contempt. And I think the lawyer was relying on some DOJ guidelines.
Or OLC or Office of Legal Counsel opinion, one or the other, or maybe both.
Right. That basically gave him the excuse that Bannon, as someone who was advising the president, was bound by executive privilege and could not, under the law, communicate that to Congress, that we're talking about the J6 committee. So the lawyer told Bannon that the law is you don't have to come. So as Steve says, his his failure to show up and appear uh, was not a willful contempt because his lawyer told him he didn't have to.
Right. And so, it's also nice for the DC circuit that they've decided, well, Congress can't do its job if people do that. But I think that's absurd because the Congress can still resort to the courts to say, well, that advice is wrong. And as a matter of law, you do have to show up. So I don't see how that's really hampering the Congress. But the other thing is that, this idea that somehow you can't rely on the advice of your counsel when you're not a lawyer, especially on a question of whether or not you have to respond to a subpoena, is just absurd on its face. What in the world do we have lawyers for if that's not their purpose? And to say that that is contempt, I think is outrageous. But it's convenient for the circuit here to say, oh well, Congress can't do its job if that's the situation, so we're gonna just stick with that rule. Now, as a technical matter, the three judges that ruled in Bannon's case are bound by the earlier opinion from the circuit that says that. They cannot overrule their own circuit. The whole court could overrule that opinion and say, well, that was a long time ago and that was stupid and that's not what the law should be. And so we're going to change that. But these three judges cannot do that. They couldn't even if they wanted to, I should say. The opinion doesn't give any indication, Steve, does it, that they wanted to
No,
rule differently?
no, there's no indication that they had any qualms about it. Uh, I want to just pick up on what the point that King made, which is an excellent one, which is that the Supreme Court, if you look big picture, when Congress subpoenas executive branch people to be witnesses, you've got a clash between two co-equal branches of the government. And the Supreme Court historically and properly has been very reluctant to get into the middle of those. And they've said, come on, guys, work it out between yourselves. Because we really don't want to get involved here. And I think that that's wise. But that simply points up that when you're an executive branch official or a former executive branch official, as Bannon was, that there are reasons to say, just because Congress says, yeah, we want you to come down and testify, Steve, that doesn't necessarily mean that you have to come down and testify, Steve. And so Bannon went to counsel, and a reputable counsel. He didn't go to some.
He didn't go to Vinny's
Right. He didn't go to my cousin Vinny. And this reputable counsel said, you don't have to respond to the subpoena. Now, as it turns out, here he is a couple of years later, and he's convicted of a criminal offense for following his lawyer's advice. And you don't have, Bannon is a controversial guy and a flamethrower, and probably was willing to run the risk here. But imagine the same situation, because it could play out just as easily with someone like, say, a Hope Hicks, some 20-year-old, in her 20s, executive branch official who gets in the cross sights of a congressional investigation with a lot of political overtones and gets told, you have to come testify. And the DC Circuit's decision says, well, you got to come testify. And if your lawyer tells you different, you can't rely on your lawyer. You've just got to come. Now, that in the wrestling match between Congress and the executive branch gives Congress a lot of leverage. And
probably too much.
Yeah, if we're looking at the long-term consequences, that's the consequence of this decision.
Right. So, go ahead,
Yeah,
King.
there's I see a potential due process issue here too. Bannon was not allowed to put on that defense. He was not allowed
Right.
to put on evidence before the jury that there was a genuine dispute between Congress and him and his lawyer as to whether legally he was bound to come. Two, he did rely on the advice of his counsel. And this was all transparent. Nothing was hidden. But he was not allowed to tell any of that to the jury. All they heard was he was subpoenaed, served with a subpoena, time and date came, and he didn't appear. And he had no, quote, legal excuse for not appearing. He wasn't sick in bed or anything like that. So that's it. That could be part of it also. Bannon has announced he is asking for an en banc review, and specifically is going to ask that old 1960 case be overturned.
Right. And so there might be some appetite on the circuit for doing that, but I highly doubt it, actually. Steve, what do you think?
I agree.
Yeah. When we survey the judges on our Court of Appeals here, there are a few right of center, and even if there were more of them, the institutional view of the circuit, I think, is that that decision keeps them out of it the most. I think that view is wrong, but that, I think, is what the court
Well,
thinks.
if you look at the panel, one of the members of the panel that affirmed Bannon's conviction was Walker, who was a young appointee. He was Mitch McConnell's guy. He is definitely a very Republican appointee, and he didn't, uh, he didn't concur. He didn't dissent. He didn't issue any disagreement or concern about this decision. So I think that tells you that the chances of the DC Circuit as a whole reversing this decision are slim and none.
Right. Now, maybe one or two of them will dissent from the denial of the on bank review and give, reasons why the decision is wrong. I think the old decision from the 60s is wrong. But then it'll be up to the Supremes as to whether they want to take that or not. That probably won't come up until the fall at the earliest, because there is this 90 days. That hasn't even started to run yet. So Bannon will have 14 days from their decision, which was Friday, right? The 10th.
Right.
He'll have 14 days in the circuit to file his petition for rehearing. And then the 90 days doesn't start to run until the circuit rules on the petition for rehearing. So, that's going to be next month at the earliest, probably. And then we'll be into the fall before his cert petition would even be due. So,
Right. If this is considered at all by the Supreme Court, it'll be next term.
yeah.
One wonders when the Supreme Court's going to sort of hit its limit in terms of Donald Trump
Trump-related cases.
But
What were you going to say?
yeah, if he gets denied by the whole court, I think odds are that that the stay of execution of his sentence will not be renewed pending his cert petition.
I think that's
I think
right.
he'll
Yes,
go
because
to jail, and
he'll go to jail in the
he will
meantime.
have served
Yeah.
his term before the Supreme Court ever takes a look at it.
Right,
Now,
but that won't move the appeal because the conviction itself still gives him standing to appeal it.
right, to petition for cert. Now, interestingly, um, so basically, you guys, what King is saying is that after the Court of Appeals denies the petition for rehearing, which we think they will do in a few weeks, then the jurisdiction returns to the district court. The case goes back down to the trial judge, who will then say, all right, well, your case is not on appeal to the Court of Appeals anymore. And so, you're going to go to jail for the sentence that I served. I can't remember what he gave Bannon. Do you remember what it
2
was?
months.
2 months. That's right. Now, Bannon will then have the ability to ask the Supreme Court to issue a stay to give him time. So he's going to serve 2 months, but he's got 3 months to file his cert petition. So he could be done serving before he even gets on file in the Supreme Court. But he can ask the Supreme Court to stay the execution, the serving of his sentence while he petitions for cert. But what's interesting about that is that I know of only one case where the Supreme Court has done that, where they have issued a stay of the execution of a sentence. We researched this before, And that case was Bob McDonnell's case from a few years ago. He's the only person, the former governor of Virginia, who was wrongfully prosecuted by the Department of Justice. And in the interest of full disclosure, it was Steve's firm that represented Governor McDonnell in that case. And they petitioned for a stay in the Supreme Court of his sentence and got it. But I think that is the one and only case where that has happened. So Bannon certainly can ask for that. Maybe he'll be the second person to get it, but that's what it would be. Okay, so any further thoughts on Steve Bannon here before we switch over to Hunter? Anything from you, King?
No.
Okay, all right, so let's talk Hunter. All right, so this week also, a different Court of Appeals, the Third Circuit Court of Appeals, which is the circuit that sits over top of Delaware. And Aaron, our intrepid former retired IRS agent, has sent me a comment here saying that yes, Arizona is indeed in the Ninth Circuit. So that Arizona case is in the Ninth Circuit, Georgia is in the 11th Circuit, and then Hunter Biden's case in Delaware is under the Third Circuit. The DC court, where we are here, where all these J6 cases are, DC has its own circuit, unsurprisingly called the DC Circuit. All right, so Hunter's case is in the Third Circuit. So as everyone knows, he's on trial in Delaware and in California since his plea blew up in his face, which we discussed with some degree of hilarity months ago.
A year ago.
Oh, a year ago, yeah, almost now. I know, it's crazy how time flies. So, all right, so Hunter's lawyers, Abby Lowell, have filed various motions to dismiss his indictment in Delaware. And the reason he's on trial in two places, Delaware and California, is because Delaware did not have venue for all of the charges against him. So in Delaware, he has gun charges pending, and in California, it's just tax charges, isn't it?
Yes.
King, do you know? Yeah, Steve says yes. It's tax. Okay, so in Delaware, he's got that gun charge pending. And the trial judge, who's the same judge that blew up the plea hearing, she has denied all of Hunter's motions to dismiss the indictment. And one of the arguments he had on motion to dismiss was that his diversion agreement was such that he had gotten a promise from the government not to prosecute him for this gun charge if he entered into the diversion agreement. So he filed a motion to dismiss on that basis, and the trial judge denied that. He also argued the argument that is sort of not getting very much traction in DC in Donald Trump's cases about whether or not the special counsel, Jack Smith, whether he's been properly appointed. But Hunter is raising that argument in Delaware about whether David Weiss is properly appointed. And the trial judge there, she denied that motion. And then he raised a final argument about separation of powers. He's basically saying that the only reason he's getting prosecuted for this gun charge in Delaware is because after his plea hearing blew up, the Congress, lost its mind. The Republicans in Congress lost their minds and basically pressured the prosecutor to bring these gun charges against him in Delaware. So the trial judge wasn't too impressed with that argument either, and she denied that. So he's had all of those motions denied. And then evidently the lawyers got together, had a conference with the judge about, scheduling, and she set the trial for June 3rd on the gun charge. And there was some discussion back in April when she denied these pretrial motions about whether or not Hunter would be filing an appeal. And his lawyer at the time told her they were not 100% sure, but probably they were not going to have jurisdiction to appeal to the Third Circuit. Because remember, in criminal cases, you cannot appeal until your case is final, and your case is not final until you get convicted and sentenced. Now, obviously, your case is also final if you get acquitted, but you're not going to appeal if you get acquitted. So nobody pays any attention to that part of it. But in the general rule is you cannot appeal until your case is final. you've been sentenced. And as we've discussed many times with former President Trump's cases, there are some exceptions to that. Um, the Supreme Court has only ever said that there are three that you can appeal interlocutory, which means before it's final, the case is final. You can appeal interlocutory bail decisions, double jeopardy, so you can't be put on trial because you've already been put on trial, and the speech and debate clause, which is in the Constitution, which protects members of Congress from being tried for stuff that they're saying as a legislator. So literally, those are the only three things that the Supreme Court has said you can appeal on the criminal side on an interlocutory basis. The courts of appeals have added a few other things to that. One of which is, and this is an argument that Hunter's lawyers use for him. One of which is, in state courts, there is usually a system for juveniles that if you are charged with a very serious crime as a juvenile, the prosecutors can elect whether to charge you on the juvenile court system or as an adult. Normally, there are statutes that say how that works. And the courts of appeals have said that if a juvenile is being tried as an adult and they ask the judge to send the case back to juvenile court, that if that is denied, that can be appealed interlocutory. The idea being that, you know, you can't not try a juvenile as an adult after you've already done it. You've already subjected the juvenile to the adult trial process. And the juvenile system and the adult criminal systems look very different. And one of the reasons we don't put juveniles through the normal adult system is because it's considered to be too difficult psychologically and otherwise for them. And so you can't undo that once you've already done it. Okay.
So one of the principal differences being that in many cases the juvenile system is not open to the public, so that if you're tried as a juvenile, it's confidential. Whereas if you're a juvenile tried as an adult, it's a public proceeding.
Right, the press is there and so forth. Okay, so that makes sense. It's the kind of thing that you can't undo it once it's been done. But the Supreme Court has not addressed that issue, but a bunch of the circuits have. The Supreme Court has set out a test for whether things can be appealed interlocutory. And this is an old case, 1949. Cohen is the name of it. And basically, it's a three-part test. So it has to be, whatever you're trying to appeal has to be a conclusive determination of a question. So the judge has to have made a ruling on it. It also has to be an issue that's separate from the merits. So, because obviously if the decision was on the merits, then you would appeal that. But you're trying to appeal something that's not the merits. But it has to be a final decision on something that's not the merits that is effectively unreviewable on appeal. So the prototypical example is double jeopardy. You know, if you get put on trial twice for something, that your whole point is you shouldn't have been put through the second trial. So why should you have to wait till that second trial is over in order to object to that? Okay, but there is also this additional gloss. In the Cohen case, the Supreme Court said that this rule applies to rights or arguments that are either statutory or constitutional in dimension. So they were trying to, again, limit, because the courts don't like interlocutory appeals in criminal cases. They're trying to limit the number of kinds of appeals that people can bring before the case is final. So they added this extra language about it has to be a statutory or constitutional claim, which leaves out basically any concept or right or claim that is common law. So, so that people know, a common law is law that is judge-made law. It's law that was developed through the courts over time. And so, for example, something that most people are familiar with is the marital privilege. Like your wife can't be called to testify against you or your husband. That is a common law privilege that the law developed over time as a policy decision that we think is bad for marriage to cause one spouse to have to testify against the other. And we value marriage to such an extent, is the thinking here, that we don't want to undermine the institution of marriage that way. But that's not in the statute, and it certainly is not in the Constitution. It's just a common law privilege. So by saying in the Cohen case, the Supreme Court saying, well, the kind of thing that you can appeal interlocutory has to be either from a statute or constitutional in dimension. They're leaving out things like marital privilege that are in the common law. Now, one thing that often is a common law idea that would be something that would prevent you from getting tried is immunity. So we had this discussion when the former president was um, uh, raising this issue about whether or not he has a common law, or whether he could raise immunity for the charges against him in DC. No court has ever said that presidential immunity is something that could be appealed interlocutory. And so I was saying on what was then called Twitter at the time, that this question is something that could be sussed out in his case, but it would be the first time that the Supreme Court would have spoken to it. Elon, is that you? Okay, so we were debating whether or not the the courts would allow that, because the Supreme Court had never said that that was an issue that could be raised interlocutory. And so what's interesting is in Trump's case, where he appealed from Judge Chutkan's order saying he doesn't have immunity, when they argued that in the DC Circuit, the judges asked the special counsel, Jack Smith, they asked his lawyers, well, one of the judges asked, are you raising the issue that immunity cannot be appealed interlocutory? And Smith's lawyers said, oh, well, we're not asserting that at this time, because they didn't think it was in their client's interest to raise it, which made me laugh because you were going to get a bad ruling on that if you raised it. But so they did not argue that in Trump's case, that he didn't have a right to appeal interlocutory. And then, as we all know, the Supreme Court took cert on it and they heard argument on it, and no one breathed a word in the Supreme Court about whether or not you could raise immunity, at least presidential immunity, on an interlocutory basis. So I'll be interested to see if that makes it into their opinion, or basically we're just all ignoring that issue. And effectively, then the Supreme Court is deciding without specifically saying that at least presidential immunity can be also something that you can appeal interlocutory. So, but that would only be the fourth thing, number 4 on their list of issues that could be appealed interlocutory. So Hunter is raising a slightly different issue. He's arguing that his diversion agreement gave him the right not to be put on trial for the gun charge. And he's saying that by analogy, that's pretty much the same thing as the double jeopardy, that the whole point is you have a right not to be put on trial. Now, the circuits have said that it's not the same as double jeopardy, that um, the issue with double jeopardy is constitutional. It's in the Fifth Amendment, and that if you have a diversion agreement or a plea agreement, that that's just a contract right. And going back to the Supreme Court's statement in Cohen that only statutory or constitutional arguments can be raised, the circuits have all said you cannot use a diversion agreement or a non-prosecution type agreement to say you didn't have a right to be put on trial, and you can take that up with the judges after you get convicted. There is a split in the circuits about whether, if the government breaches a plea agreement, you can take that up as an interlocutory appeal. So Hunter is making this argument, which logically is the same as the double jeopardy situation, but he's running into this previous law, the previous rulings that say, well, it's not the same, and you can't take it up now, even though logically, just applying regular logic, forget about the law for a minute, it isn't really any different. Um, So he ran this up the flagpole with the Third Circuit. He filed his notice of appeal on April 17th, right after the judge ruled. And that same day, the Third Circuit's clerk issued an order basically saying there was a question about whether the appeal was based on a final order and directed the parties to file a response within 14 days to, and the clerks, they don't usually do this on their own, although they are empowered to do some things like this by themselves. But normally they've gone to a panel of judges and the judges have said, yeah, we think this is a question, a preliminary question of law. Tell the parties to brief this question, and then we'll rule on that only. And they, before we even set any kind of schedule for the regular case. So the clerk issued an order that same day saying this is a case where the order that's appealed from might not be final, and the parties have 14 days to say, well, what do you think about that? 2 days later, the government, the special counsel Weiss's office, filed a motion to dismiss for lack of jurisdiction. And they also filed a motion to expedite the motion to dismiss, saying, well, we have a trial set for this case, June 3rd, which was, less than 2 months later. Which that was interesting because then 2 days later, not the clerk, but a judge from the Third Circuit denied the motion to expedite, basically saying the court knows when the trial date is. We already told you to file responses on this finality issue within 14 days. So get your response on file by the 29th, and we'll rule on it when we rule on it. Thank you very much. So they both filed their responses on the 29th, and then the government filed a reply because it had filed this motion to dismiss on May 6th. And then on the 9th, which was Thursday, the circuit said that Hunter's appeal is premature, that he cannot appeal this on an interlocutory basis, that he has to wait until after he gets convicted, if he does, and sentenced in order to appeal any of this. So the it's pretty straightforward application of what the existing precedents say from both the circuit and the Supreme Court. But I think that Abbe Lowell, he is making some good arguments that the the logic of it doesn't make sense, though, that you can't appeal this. The Supreme Court often says that to get interlocutory relief, it has to be the kind of right that gives you a right not to be tried. Well, this is certainly that if the agreement is in force. He also points out, and King, did you notice this, that the judge out in California on the tax cases, he ruled that the agreement is in force and enforceable, but he said that because the probation officer hasn't signed the agreement yet, that the government's obligation not to try Hunter hasn't started to run yet. And so, even though the agreement's in effect, that provision isn't in operation yet. I read that and I was like, what in the hell is this? King, what do you think
I
about
read
that?
that and it made no sense.
Even the judge admitted that, guess what? Get this, that this was kind of a Schrodinger's cat analysis of whether the cat's dead or alive in the box, because the agreement's both in effect and not in effect, which that's complete fucking nonsense, is what that is. And you can quote me on that, people. So all right. So at this point, what I really wanted to ask you guys about is, like, okay, what's Hunter's lawyers going to do? So Abbe Lowell was quoted as saying the following about this ruling. He said, in reviewing the panel's decision, we believe the issues involved are too important and further review of our request is appropriate. So what do we think? Is he going to seek petition on bank or cert on this, or what?
I think you better get ready for trial.
Well,
Right, because he's going to need a stay. Well, he's technically got to stay for another 14 days, right? So,
right. But look, I complimented George Terwilliger earlier, and I'll compliment Abbe Lowell in the same way now, even though the politics are a little bit different. Abbe Lowell is a very accomplished lawyer. and he's not in the habit of saying things he doesn't mean. So if Abby Lowell says he's going to seek review, he's going to seek review.
I mean, he doesn't come right out and say that, but he more or less implies it, right?
He has effectively said that. Now, I don't disagree with King when he says, yeah, he may seek it, but that's not going to necessarily get him a stay. He'd better be getting ready to go to trial. But he's got a good argument. I mean, as you pointed out earlier, Leslie, there's a split on whether you can take an interlocutory appeal on a breached plea agreement, but the courts have not yet said that for a non-prosecution agreement. But analytically, from a lawyer's perspective, there's no real distinction and difference between the two of them. When the government enters into an agreement with a defendant in a criminal case, or a potential defendant in a criminal case, about how it's going to handle the case, that's a contract. And the Supreme Court said many years ago in Santabello that that's a binding contract, and the defendant can hold the government to the terms of its contract. And that's what we're talking about here. Now, people are not particularly sympathetic to Hunter Biden, but the issues here are to some extent the same issues that Donald Trump is raising in some of his cases. And the law is neutral on any of this. The real issue is supposed to be neutral on this. So the real issue is keeping the government within the limits of its power and making sure that it doesn't overreach. Now, the government, for better or worse, entered into this deal with Hunter Biden. I think it was an ill-considered deal, but they entered into it, and then it blew up when the judge said, I have some questions about it. But Abby Lowell, as he's got every right to do, and as any good attorney would do, would say, just a second, the government's committed itself, and it can't back out now just because the judge didn't like some aspects of it.
Right. So, it's fascinating to me, sort of what the point Steve was just making, the overlap, legally at least, in some of the issues that are being raised for the former president and for the current president's son. I mean, we're living in astonishing legal times in some ways. So, right, King. So I agree with you that he needs to be prepared for trial, Abby. But, let's just pretend we're him for a second. And we've got an associate preparing for trial, because Abby will probably participate in the trial and may even be lead counsel in the trial, but it's not going to be much of a trial. So he's going to have plenty of time to be prepared. But what do we think? Do we think he'll seek a stay
I'm sure. Yeah,
from the Supreme Court? I mean,
I wouldn't be surprised for him to both seek a stay and seek relief wherever he can. But
right.
but there's something arguing against him in this one. This was a unique agreement. Nobody that I know had ever seen anything like it before, where you have a on the right hand you have a diversion agreement as to the gun charges, and on the left hand that contained a non-prosecution agreement as to everything else Hunter was accused of doing, and not in the form of a plea agreement that has to go to the court for approval of the entirety of the agreement. And the judge called them out on that. And basically, they stood up and said, well, we don't have a meeting of the minds. So you have a fact-intensive dispute that he's trying to bring to an en banc review by the Third Circuit and maybe ultimately by the Supreme Court. That's the kind of thing that appellate courts shy away from.
Right, they don't like, yeah. Right. It's not as clean a legal issue as a lot of the other issues that we've been talking about. So, but he does have also the amazing argument that there's this other judge who's ruled differently, and so it's a question of interpretation of a document, which is, like that's what judges do all day long, every day, right? So, There's no real questions there to be put in front of the jury, right?
Well, the jury doesn't get into any of this plea bargaining.
Right. So how is it not completely collateral to the merits, which I think supports his argument that this is something that can be reviewed interlocutory?
I agree that I think it can be.
Right, potentially. So it's interesting that maybe the Supreme Court has a different view than the courts in the past did about how narrow this slice of cases has to be that you can take up interlocutory, because these political cases are just driving the law in the direction, to be honest, of actually a little more fairness. You know, your average person who gets charged with any of this stuff, if your name isn't Hunter Biden or your name isn't Trump Biden, Biden Trump, whatever, you have no prayer of a hope, of a chance of getting the Court of Appeals to pay attention to any of this. But with these, political dynasties, that's what we're going to get. So, all right.
And they're questions that are worth the courts
Yes,
looking at.
they
These are
are.
worthy questions. It's a little, it's sad that it's had to get raised in such a political context, but at least it gives some chance of the courts finally paying attention to them and giving them some serious attention.
Right. And maybe making rulings that will be good for the law for other people.
Right, for the average person, and not just somebody who is the former president or the son of the current president.
Right. All right. Well, that's pretty much what we wanted to cover tonight. King, have you got any final comments?
That's all I had. I see Mr. Musk is requesting.
he, he keeps trying to get in, but I don't think it's the actual Mr. Musk.
Okay.
That would be interesting if it were, but I think not. So, okay, well, then as I said, we are going to be covering some of the other things people are interested in, but not tonight. We have a lot going on. And as you can see, Ship wasn't able to join us tonight because of his responsibilities for some of his clients. So we're going to talk about the stuff going on in Florida later on, in the next few weeks, well, the next probably 6 to 8 weeks. Although, King, I did want to ask you, I was hoping Ship would join us for this question, but I'll ask you what you think. Judge Cannon this week, the development there is that she took her trial date off the calendar. Um, and so that raises the question we've discussed with Ship many times. Do we think Judge Chutkin will, once she gets the DC case back from the Supremes, which should happen in summer, will she then try to set a trial date? She wasn't going to be able to use the May date that Judge Cannon was holding anyway. So do we think this is going to have any effect actually on Chutkin's trial schedule? Steve says no. King, your
I
views?
don't think it will. We she was always looking at a trial beginning at the earliest in September, and
She,
Judge
Chutkin.
Chutkin, and probably later than that. And with all of the uncertainties surrounding the immunity question, which I don't think is going to be resolved by then, because if, assuming that the Supreme Court decides some form of immunity is at least possible, and we're going to have to send it to the trial court to decide the parameters of the scope of that. Uh, that that all has to happen before a jury trial on the charges themselves. So
And probably another round of appeals, don't we think?
exactly. So I
Yeah.
don't think whenever the Florida case starts, I think it's not going to have any bearing on the DC case. It looks like Florida case is there's no trial date in sight right now. Uh,
Right. And that's because of all the issues having to deal with classified information.
well, more than that, you've got
Mhm.
a she has set an evidentiary hearing for the third week of June. She set aside 3 days for hearings, some of which will be uh, taken up, taking evidence on the issue of who is the prosecution team, that is, which government agencies will be deemed by the court to be part of Jack Smith's group of prosecutors for purposes of searching their records for classified information and Brady material and Jenks material and all of that. It would put a huge burden of discovery on Jack Smith if he has to go that far. Uh, but Trump has a decent argument that there were, and he's going to put on evidence, that there were meetings well in advance of the grand jury between and among the White House, the NARA, the
Archivist.
archivist, and the DOJ and the FBI, and maybe some more. But all of them were in discussions and kind of joined together in deciding how to prosecute this case and what to prosecute, what charges to bring. And
And so people know that that's not illegal in and of itself, right? The United States government is one legal entity in many ways and in almost all ways. All the various agencies are separate in some ways, but the United States is one cohesive government at the same time. And so there's no rule at all that says that DOJ can't consult with the archivist or can't consult with CIA or the White House or whoever in terms of bringing cases. There's nothing wrong with that legally, but typically DOJ is not doing that because the case doesn't need for that to happen, or the DOJ is consulting with one agency. So let's say the guy's being charged with bank fraud. Right. They might be consulting with the Treasury Department, right? Or housing, low income housing program fraud. Then they're going to consult with HUD. And so you'd have an investigator from that other agency that's part of the prosecution team. There's nothing at all wrong with that. It's very common. And obviously, IRS, right? Tax cases, obviously, the IRS is involved in that. But where it becomes interesting for lawyers is that Brady, which most people I know recognize that Brady is the word that people use generally to describe what obligations does the government, the prosecution, have to give discovery and evidence to the defense to prepare for trial. So this part people don't usually know. If you get prosecuted by the federal government, you don't have a right to any information about your case that's in the possession of any part of the federal government. The courts have said that you have a due process right to information that's relevant to your case, but because the prosecutors have to give you information that would tend to undermine their case or tend to show that you're not guilty as a matter of due process. So if the prosecution team does not have that evidence and hasn't used it or considered it in deciding whether to prosecute you, but it's hanging out in some other agency's files, but they don't know about it, that's not a due process violation, basically on the theory that they're not using it against you. You don't have a right of discovery as against the entire government. Now, you can seek to have subpoenas sent to other government agencies. You can use the process of the court to try to affirmatively get evidence to help you in your case. But Brady is about the government's obligation to give you evidence as a matter of due process. So, one thing that gets litigated, and this is what the former president's lawyers are doing for him in Florida, is you litigate where it's not a standard case where it's just DOJ and maybe one other agency, but where there are other agencies involved, you can litigate who is included as part of the prosecution team for purposes of discovery and for purposes of Brady. And if a judge rules, two or three agencies are actually functioning as part of the prosecution team, that expands and sometimes exponentially the amount of work that the government has to do in providing you discovery, or they have to go and look and they have to consult with that agency, and it places obligations on the lawyers for that other agency that otherwise would not exist. So it's not uncommon, but it's not super common either to be doing this kind of thing. It happens a lot in complex cases. So Trump's lawyers have, really, I think, put together a good um, attack in this way for him. King, what were you going to say?
They've done one thing that I've never seen or heard of before. They put a target on the White House in
Yeah.
general as being in charge of a political prosecution or more than one
Right.
political prosecution. And I expect them to put on evidence of meetings with uh, Mr. Wade, Fonnie Willis's boyfriend, and meeting with the prosecutors in New York, etc. That this whole thing is a political game plan to prosecute a political opponent, and they're going to try to tie the entire White House and the White House counsel's office into the prosecution team in this case.
Well, and this would give them two bangs for their buck because by raising it as a discovery and a Brady issue and getting a judge to make ruling that certain other agencies were involved, then you're going to get evidence of that. Like if the judge says, well, you have to turn over documents that you have, that the White House counsel, I'm just making this up, that they have, from the meetings and whatever, you're going to end up probably with information showing the coordination, and then you could potentially use that. This is where you're going with it, right? You could potentially use that to show that, not just for discovery or due process purposes, but to show that you're being prosecuted on a political basis, which would be a different motion that you would then bring for selective or improper prosecution, right? That you're being prosecuted not for the crimes but for political purposes. So that motion doesn't usually work. On the other hand, there's not usually good evidence that you've got to build it up, much less prevail on it. So he's going to get two bangs for his buck here, King, don't you think, with this ruling from her?
Yes, he has actually filed a motion for selective prosecution. Uh,
Right, and
and,
that happens a lot, but usually it's not based on a whole lot of actual facts and evidence. And here he's using this other motion to create those facts.
no, he has a baseline of facts. He's got
Yeah,
all of the former presidents and former federal officials who've never been prosecuted for mishandling classified documents, including the current president. Uh,
right.
so that's the basis of his selective prosecution motion. But he would like to tie into that what you described, a uh, improper use of judicial proceedings to punish and persecute a political opponent.
Right, which isn't really, from a strictly legal point of view as a defense lawyer, that's not really a selective or a vindictive prosecution motion. It's something else, which isn't to say that it's not valid or viable, but it's not usually the argument that you make for selective or vindictive prosecution. But on the other hand, this is the first time that there's been prosecutions of a former president. So, we shouldn't be surprised that the arguments are somewhat different. And his lawyers are having a hard time in some ways fitting them into like the motions that you would normally put in front of the judge, right? So, yeah, but we're going to keep a close eye on what Judge Cannon does with all of that. She is also, as I understand it, King, is this right? She's set a date to hear the motion that Ed Meese keeps filing as amicus counsel with the Supreme Court about whether Jack Smith is appropriately appointed.
Yes, uh, it's around the same time that you'll hear that. By the way, that motion is not the same as the motion that Hunter filed. Uh, the base the main basis for Hunter's motion was that special counsel Weiss was not outside the government, and
Right.
whereas the DOJ regulation on special counsel appointment requires the special counsel to be appointed from outside the government. But that argument has failed several times before. Mises is unique. It's more of a constitutional argument and
Right.
statutory. It doesn't rely on the regulations at all.
The regulations. Yeah. Right. But it's just fascinating to me that you've got these cases and that they're both making this argument that the special counsel is illegitimate, basically. So Hunter argues in his that he should be able to appeal that now. Also, the point that, if Weiss is not properly appointed, then anything that he does is what lawyers call ultra vires, meaning it's outside of the legal power to act. So it makes whatever if an official is acting in a way that's called ultra vires, it means they don't have the authority to do what they're doing, which makes it a nullity, meaning it's just whatever they've done, they did it, but it doesn't have any legal effect. And there are some recent cases from the Supreme Court on this issue. This case called Lucia was decided a few years ago, where administrative judges at certain agencies like the Securities and Exchange Commission were not properly appointed. And that went up to the Supreme Court, and the Supreme said, right, they weren't. And therefore, any acts that those administrative judges took were not legally valid. So it's an argument that this official acts acting outside of the law, and therefore his actions have no legal effect. So all of that is up and coming for us. King and I are going to be keeping an eye on it, and we'll talk about it in the weeks to come. In addition to the rulings when they finally come down from the Supreme Court. So, okay, King. Anything else from you tonight?
That's all I have, except Happy Mother's Day to everybody, all the moms who are listening.
Yes, I concur. All right, Steve, you got anything else?
Nope.
Nope. All right, Steve and I have to get back to packing because we are moving finally. So exciting times. Shay Gordon. So thanks for listening, everybody, and we'll